All right, guys, let's get started. Let's get started. I'm glad everybody is here. And thanks, Alan, for that feedback. I appreciate it. Okay. So I've been changing my my poll. You know, usually I would ask like, hey, do you guys know me, this and that? But there's always somebody new here. So I'll give you a quick intro, but I want to actually focus on what's more important. Soon we're gonna get back to normal here, right? I mean, we're expecting to basically be done with the online classes pretty much in May, and then we're gonna still do some online classes and beyond the full day classes. But I would like to keep these webinars going, right? I want to come up with new topics. I want to answer your guys' questions, but I do need your help, right? To make it worth it for me, right? To wake up at midnight and to be here on a Saturday, right? In order for, okay, DUI, there you go. I'll add that to my list. Okay, but you guys, I will deliver for you, and I will deliver for you, but you have to help me spread the word so we get every single class is packed. If we're doing that, then it's worth it for me too, and it's a good exchange. All right, another one, personal discipline. Yep, internal investigations essentially, right? So an IA class, Brady, Garrity, all that kind of stuff. Okay. All right, Galaxy S9, DRE. I will do trafficking. How about I'll do how to articulate trafficking and so forth. But DRE, I'm not an expert in drugs, but I am an expert in articulating when you have somebody's reasonable suspicion or probable cause that they have trafficking evidence. So I'll do trafficking. One that I'm working on right now that you guys really, really want is when can you search the vehicle and also the occupants? It comes up all the time. Cops are flooding my email with you know, when can we search the passenger with a dog alert and so forth? The answer is sometimes a little complicated, and I will give you a lot of case law on that. And also undercover issues, absolutely. Actually, I have a lot of undercover stuff. So are you from California, Dan? Yep. All right. So use of force, probably, this would be California centric. Okay. So guys, my name is Anthony Bandiero, an attorney and senior legal instructor with Blue to Gold Law Enforcement Training. This is what I do, right? This is all I do. I am not, you know, a prosecutor. I don't do, all I do is support you guys, and I also help prosecutors, you know, with learning the search and seizure. This is my bag. This is all I do, and I feel I'm pretty good at it because, again, I concentrate my professional life in the Fourth Amendment and its analogs, right? The state equivalents. Pennsylvania does a few things different. New Jersey does a few things different. Oregon does a lot of things different. And so, but you know, this is what I do, and I have the best job in the world. First Amendment audit people that tape. Actually, that one's already out. That's called Cops and Cameras. So somebody's asking me for the First Amendment class. I already have it, Cops and Cameras. And by the way, it's one of my favorite subjects. So make sure you go see Cops and Cameras, okay? And maybe Rick is on and he works with me. Maybe he can shoot out when the next date is for that. Another thing is we made a, thanks. We made a business decision the other day. We got all around and we didn't want to have any stops with people taking the webinars during COVID-19. So we were having some paid webinars. We got rid of all of them. All webinars are free. All webinars are free. Even the ones that we were originally going to charge for, they're all free. Thank you. I love Cops and Cameras. That one will save your ass. That one will save your ass. That one will save you some money. Guarantee it. Guarantee. I have 2 books, and again, I just kind of want to plug it because a lot of you guys have been, you know, you guys like what I'm teaching, but a lot of what I teach is from the books that I write. You know, I'm just sharing I'm verbalizing. So, yeah. So Brandon, Rick answer that. Brandon has a good question. Oh, you do see it. You do see it. Brandon is, yeah. Yeah, okay. I'll add that one too. That's going to be, marijuana law is always complicated, but I will add that one about marijuana law. So guys, consider getting the book. Consider getting the book, and both books actually. There's a deal right now, but this will help you so much. This will help you so much. Help you articulate what's important when you have your cases, and also keeping you out of trouble in civil lawsuits and so forth. Disclaimers: laws and agency SOPs may be more restrictive, right? So just remember that I'm teaching you what I think the law is at a federal level. Now, the good thing is that most states are they're pretty much all, their search and seizure law is almost entirely federal, right? They match the U.S. Supreme Court. A good example of that is California and Florida. They have constitutional amendments that say as much. Other states like Texas and Tennessee, they're pretty much on board with the Fourth Amendment, which is great for somebody like me because that's my specialty. But some states go off the rails a little bit. They say, you know what, we don't like what the Supreme Court's doing. We are going to change that under our state constitution. But the good thing is about 90% of what I teach is the same nationally. If you have any doubts about the legality of your actions, push up the chain. And finally, this course is legal education, not legal advice. I can't give you legal advice over this medium, right? I can only tell you what my opinion is, and take it or leave it. All right. You got that right, Mike. You got that right. So, certificates. We have people that are shoulder surfing, right? We have people that are like, hey, what's this guy all about? What are you watching over there? If they watch the webinar, make sure that they get a certificate too. And the certificates are fill in the blank. I will let you know that I am in the works of having the ability to send you to send you customized certificates with your name on it and so forth, just like we get at paid, our paid students in our full day classes. I'm working on it, but Zoom did not have that functionality, so I have to build it myself and so forth. But soon you will not have to download these certs. I will send them to you through your email. But until then, download them. Here's what we're going to talk about. We're going to talk about some latest cases. This one is going to be, I think, a little interesting. This is going to be a topic today. We're going to talk about cameras and Lprs, license plate readers, and poll cameras and so forth. You guys may or may not be involved in those discussions, but it's actually a very interesting topic, and especially for not only if even at your level, like let's say you're a line officer and you only have a few years on, but you're going to be a boss one day, or you're an attorney, or you want to be in I'm going to teach you some good stuff to think about where the Fourth Amendment is heading. So we're going to look into the future, but also remember too that these are still core principles of the Fourth Amendment. So even though we're going to talk about poll cameras and so forth, this is things that you can apply to other searches and seizure issues. And so I just have to write down something real quick that somebody told me. So, okay. All right. So here is a case that just came out on April 16th. Okay. And it's from Massachusetts Supreme Court. And what happened here is a guy named Jason McCarthy, right? He is a drug dealer in Boston, and he meets up with his counterparts in the Cape. And what the state police do is they have Lprs, automatic license plate readers or license plate readers, but they have Lprs on the bridges that go to Cape Cod. And they have one going in and one going out, right? On both bridges that go to the Cape. And they track every license plate. And if you put in the database, if you put in a particular license plate that you're targeting, then it will alert the officers, right, when that guy goes across the bridge in what direction. So McCarthy's driving his black Hyundai sedan, and they put the plate in there. And, again, he's the target. And he's been going to the Cape like several times per week. And they followed him, and he doesn't go there for tourists. He meets people in a park. They do whatever, like transact or talk, sometimes just talk. but sometimes they hand each other stuff. And then McCarthy just goes back to Boston. So one day, the LPR alerts that he's on the way to the Cape. So they go to where he thinks he's going to be, which is that park. They surveil him. They do not see him, handing anything back and forth, but they're like, you know what? It's time to go talk to this guy. So after he leaves, they pull him over for reasonable suspicion of narcotics. They put him in handcuffs, and they read him Miranda, which is the right thing to do because it seems like arrest-like. I don't know why they just put him right in handcuffs, but they just did. So, but Miranda's required. He did waive. He incriminated himself. They found a crap load of drugs in his house and so forth. What the case is about is that license plate reader. So what he is saying is that this license plate reader, the way you're using it, is a search under the Fourth Amendment. And this is a good example of, how the book is used, right? What is a search under the Fourth Amendment? Well, there's actually two searches under the Fourth Amendment. I don't know if you knew this, right? There's actually one is a Jones search or a physical intrusion. When you enter or touch a protected area or thing like a car, and your intent is to gather information, that is a search under the Fourth Amendment. Well, that doesn't apply here because they didn't touch his car, right? There's no trespass here, so get that one out. The next type of search is what's called a reasonable expectation of privacy search. You've heard of this one, the REP, right? Reasonable expectation of privacy. And in order to have a reasonable expectation of privacy, you have to have two factors in play at the same time. Number one, does the suspect himself have a reasonable expectation of privacy? If a person has a kilo of coke on his kitchen table, and a cop walks by on a public sidewalk and looks in the window and sees that kilo of coke, that person does not have a reasonable expectation of privacy under those circumstances because it's in plain view. If a person is in a bar talking loudly about a drug transaction and an undercover cop hears it, that person has no reasonable expectation of privacy that their conversation will not be overheard. However, if a person is in a park talking to somebody and there's nobody around, and the cops use a laser mic to pick up their conversation, that is a search under the Fourth Amendment because that person does have a reasonable expectation of privacy. And the second thing is, would society recognize it as reasonable? So you need both. But I'm going to tell you right now that in the real world, number two is more important. Okay? Does society look at it as reasonable? If society thinks that the cops are being intrusive, then they're going to say that that's a search, which requires some justification. I call that crew. Whenever you do a search or seizure under the Fourth Amendment, you need crew. There are no exceptions. And this is the acronym stands for this. Do you have consent? Do you have consent from somebody who can give it? If you do, then even though you may have been intrusive, you are allowed to do it. Or do you have a recognized exception? A recognized exception is another way of saying, is there a court case on this that tells you that you can do what you're doing? And number three, do you have a warrant? That is what is reasonable under the Fourth Amendment, those three broad categories. Now, sometimes there is no exact case on what you're doing and you are making case law, but you should have some analytical framework or you should have some justification about why you're doing what you're doing when you're making case law. Anyway, so you need both at the same time. So for example, okay, if you stop a car and the car is stolen and the person is a thief, right? It's not a situation where the guy thought he was not driving a stolen car. In other words, he asked me if he can go in my car to go get a six-pack. My car's stolen, but he doesn't know that. Well, right? I mean, then he has a reasonable expectation of privacy as to him and so forth, But if he knows the car is stolen, he cannot have a reasonable expectation of privacy in that car. Generally speaking, the rule in New Jersey, by the way, is a little bit different. It doesn't really matter for our discussion, But my New Jersey people, the rule is a little different. They do not care about subjective mindset. They only care about the second issue. What society think it's reasonable? If you have questions on that, ask me and I'll tell you. But anyway, so that's what's going on here. But let's be straight here. Using that test is difficult in the field. I've never seen a cop go like this. I don't know. Does that suspect have a reasonable expectation of privacy? Okay. Is this something society will consider reasonable? I've never seen a cop do that, and I don't think you should, because that'd be it's just too complicated. So I came up with an easy test to use in the field, and 98.3% of the time, you're going to be right. In other words, I'm joking. 98.3% of the time, you are going to come up with the same conclusion that the courts will come up with. And this is my 100-person test. When you are looking at whether or not somebody has a reasonable expectation of privacy with the LPR readers, poll cams, drones, thermal imaging, ask yourself, if I got 100 people of my community in a room, now these 100 people are not all cops and they're not all criminals. If you ask a room full of all cops, hey, can I search? They're gonna be like, hell yeah, let's get that guy. And if you ask a room full of 100 criminals, can I search? They'll be like, hell no, let that guy go. So we use a community standard. In other words, just Joe Sixpack. Hey, Joe Sixpack. If you're driving on a highway and an LPR reader, tags your plate, do you have did the government violate your reasonable expectation of privacy? What are they going to say with those facts? Yes or no? You're right. The answer is no. The answer is no, right? I mean, it's just not reasonable. The DEA has a bunch of license plate readers across the United States on highways. However, we're going to push the envelope on this and find out when it does become a search. But generally speaking, so Jacob brings up a good point. We can always run plates that are in plain view. However, it gets complicated. No, anywhere. New York, New Jersey, Texas, California, that's the rule everywhere, because there is no reasonable expectation of privacy in a plate, nor in the database that's behind it. That's everywhere. But we are not going to stop there, because this is an advanced class. We are going to dig deeper and find out what's really going on underneath the hood. Can you hold on to make sure you guys can hear me, right? Everything should be good. Okay, so society, right? I think that there is a person on the top of this, in the top floor of this building, that is a felon with a gun, right? With a felon with a gun. So I want to use my my binoculars. Okay. Now I cannot see with the plain sight. I cannot see anybody in that apartment, but I can now see with my binoculars. Society, 100 people. Am I good? Yes or no? Okay. You're absolutely correct, by the way. The answer is no. The answer is no. This violates a reasonable expectation of privacy. Why? Because you cannot see in that house with plain, with plain sight, and there's no vantage point that you can get to actually see it. This would be under these facts, this would be a invasion of privacy. Hey, society, I can actually see the guy in this next building over. I can see him, but I can't see exactly what's holding in his hand. Can I use binoculars to clarify what I see? Or yes or no? The answer is yes. The answer is yes. The answer is yes. Here's why. It's not overly intrusive. It's not overly intrusive. He is now look, right. He knows that there's a building right next door. Does he think that nobody's ever going to be looking at him from that building? No. Therefore, if he's running around with a gun in his hand, he takes the risk that somebody will see him and clarify what they see with binoculars. That's the binocular rule. You can read more about that in the book, but my point is, this is how you use the 100-person test, and normally you will get back to the right answer. So now let's move on to the next issue, which is the tracking, okay? Now, our case comes from Carpenter, okay? In Carpenter, it was all about cell phone tracking using cell phone location information, cell site location information, right? And so this has been a struggle with the courts, okay? Because, right, and okay, you're answering, no, you're fine in the park, but here's the thing, the rule here is if you are in a park and you're looking at a home, no problem. But if you want to look in the windows, right, you have to be able to see something first with plain sight before you can use binoculars, because when you use binoculars, you are being intrusive to some degree, and if you are seeing things which are not open to plain view, or at least slightly, then you are being overly intrusive, and that's the general approach under the Fourth Amendment. So remember, there you go. Okay, so now we're going to talk about a case called Carpenter. What happened in Carpenter was 5 suspects were robbing T-Mobile stores, maybe Metro PCS stores and so forth. Okay, so they were robbing these stores. The feds get. Then they're going all around like the Michigan area and so forth. Okay. So Franco, the answer is no, that's not the rule, and I'll explain more at the end of this and I'll actually talk about what the book says and so forth. I thought you have the book too, I think, coming, don't you? If I'm not mistaken. So, right. So I actually have a whole chapter on binoculars, just so that we're clear, so you don't get in trouble. Okay, but I'll talk more about it later. So in Carpenter, what they did was the feds, they requested through a subpoena, which is not based on probable cause, so it's not a warrant, right? They requested that the Carpenter's cell phone company, right, Sprint, I believe it was, give the feds all his location information for the last 120-something days, 121 days. And based off of that information, what did they do? They said, hey, every time there's one of these armed robberies at the T-Mobile store, guess who's in the area? Carpenter. Now, the government argued that this is not a search, and the argument is not frivolous. And here's why. There's something called the third-party doctrine, right? So the third-party doctrine under the search and seizure under these circumstances means that if somebody gives their information to a company, a bank, whatever, a cell phone company, if they voluntarily give that information to somebody, then they have no reasonable expectation of privacy in it if that company voluntarily gives it to somebody else. So that's what we have going on here, is that the cell phone company is giving their information. It's not owned by Jacob or by Carpenter. It's not owned by Carpenter. It's owned by the cell phone company, right? And they use it for marketing and so forth. And they keep 5 years of this data. They hand it over. But, okay, so if you ask 100 people in the room, hey, do you have any expectation of privacy in the GPS location of your phone and that it's giving off to Verizon and so forth? In other words, can the police just grab that information without a warrant? Yes or no? So the answer is, well, so here's the deal. That contract is part of the argument, that I know that when I use my phone, that Verizon has that information and so forth. And I should be clear that maybe I didn't put the question correctly. The question is, and I should be more clear about this. It's whether or not the government can demand that information from Verizon without a search warrant. Yes or no? Okay. That's really the question. If Verizon gave the information voluntarily, that would be a little different. Okay, that's a different question. So, but that's what the government did. Why? Because that subpoenas have to be complied with, right? Or it's contempt. So Verizon or Sprint, whoever, right, has no choice in the equation. They're not just asked. And if they were asked, that's a different question, which was not addressed in this case. So this is called the Mosaic Theory. The reason why you have a reasonable expectation of privacy, even though the contract, you know that Verizon's capturing your information. You know that if you look online, you can see that that's 5 years worth of information and so forth. Right? So the thing is, okay, I'm going to answer that in a second here. What the courts are saying, this third-party data, is that even though it's not my data, it's not your data, it's not Carpenter's data, if the government had an absolute right to just grab that data with just a subpoena, which is not, again, not based off probable cause, just a reasonableness, right? Just a reason to believe it would help an investigation, then the government can essentially, tell you or know what you're up to. If I had the last 5 years of your tracking information, do you think I would know what church you go to, who you're dating, right? What you eat, who you're friends with, where you bank, and all, right? What's your interests? So that's the problem, right? And you look at just these factors, right? It's just that it's no longer just because it's third party, it's no privacy. If we do not add some protection to this information, then you essentially have you short circuit the Fourth Amendment. So here are some factors to consider, right? When you're using this, either LPRs, poll cameras, and so forth, right? How long will the surveillance be conducted? That's a very good question. If it's 1 day, 2 days, 3 days, that's a whole different case than 3 months, right? Is the surveillance done in secret, right? I think about New York, and I think about going down in Times Square. There's cameras everywhere, and in fact, they're like, it says New York Police, and so forth, crime control, whatever it says. It's like it's putting a lot of people on notice that you are being filmed 24/7. Now, that's not the only factor. That's just one factor, is notice. The other factor is, does the technology give police access to information previously unknowable? What they're trying to say here is this: the courts would like to keep a level of privacy that was kind of similar in 1791, which is when the Constitution was passed. It would be nice if that technology did not just completely eliminate the Fourth Amendment, right? And if we don't put a check and balance in place, the Fourth Amendment is dead, because the facial recognition, LPRs, what I think about in Vegas, right? They have almost every intersection has a camera. What if they just downloaded some software, and those cameras were now able to actually act like LPRs overnight? And now you can actually track somebody. You don't need a GPS tracker. All you need is those LPRs. Do you think we have a constitutional issue, yes or no? Because it's the Mosaic Theory, right? Imagine that's what it would look like if every single intersection had a camera and was tracking license plates. And you just put in there ABC 1, 2, 3. Oh, well, look at Anthony. He's been going all these places for the last few weeks. You don't need a GPS on a car. You don't need to put a physical tracker, because Jones, which is U.S. Supreme Court case Jones, said you can't do that. You have to have a GPS tracker. Screw the GPS tracker. All we need is LPRs. And that is what this case out of Massachusetts is starting to discuss. A lot of feds have asked me, Anthony, what are the ramifications on these LPRs and so forth? Because we use a lot of them. There's an agency in California, Redlands, California. They use LPRs to track people going in and out of certain high crime neighborhoods. So generally speaking, the answer is go for it. However, there is a limit. There is a limit. As this court and the United States Supreme Court interpret society's reasonable expectation of privacy over time, the court's overarching goal is to assure the preservation of that degree of privacy against government that existed when the Fourth Amendment was adopted. In other words, it would have been absolutely impossible to put, basically have the equivalent of a 1 million person agency that can watch everybody at all times, right? I mean, if there's one citizen, right? I think, what was the thing I read? It says, in order to have 24-hour surveillance of somebody, it requires, if I'm not mistaken, 16 officers, something like that. I'm probably off, but it's a lot of officers in order to cover shifts, holidays, vacation, and so forth. If the government wanted to track somebody for 24/7 in the public, they would need essentially a squad of like 16 officers. Screw that. Just do it with cameras. We don't need 16 officers per one. We need one camera on every intersection. You get my point. And if we allow that, then the Fourth Amendment is dead. In many, many ways, it's taken a huge strike to the heart. So, while acknowledging the usefulness of these tools for crime detection, both this court and the United States Supreme Court have been careful to guard against the power of technology to shrink the realm of guaranteed privacy by emphasizing that privacy rights cannot be left at the mercy of advancing technology, but rather must be preserved and protected as new technologies are adopted and applied by law enforcement. Guys, this is cutting edge. For my young officers out there, I will be dead. You will be the chief, commander, colonel, whatever you want to, right? You're going to be in charge one day. And you're going to have to address these issues in your department. You're going to have to answer some questions about when can you deploy drones, right? Because think about it. Drones are so cheap right now. What about having 24-hour surveillance and just having drones in the air? You don't need a helicopter. A helicopter is a $3 million expense, plus probably $500,000 a year in overhead. Screw that. Buy $100,000 worth of drones, have them deployed all over your city. It sounds right. It sounds far-fetched. It is right now, but obviously it's not 10 years from now, 20 years from now. Where do we go? This is what the court is starting to talk about, and I find it fascinating because this is the future of the Fourth Amendment, right? It's not snooping in ledgers. It's drones. It's LPRs, and so forth. Here are factors to consider when using LPRs. This is what the court has talked about, right? First of all, how many LPRs? I just gave you a great example of somebody coming up with a software program and turning every single intersection camera into an LPR. That is absolutely possible, I think, right now. I'm not positive how detailed those cameras are. In other words, what's their resolution? But I would think that they have the ability to read a license plate if it's a modern camera. How long will the information be retained? That's another thing. I was asking the California agency that question. How long do you guys keep this information about people coming in and out of neighborhoods? They said, we don't have a retention policy right now. We keep it. And I share with them that is right. That is likely, that's going to become an issue because courts are not going to want to hear police agencies saying, hey, we never get rid of LPR data. Well, now Massachusetts kept it for a year and the court didn't mind that, right? Are LPRs placed near constitutionally sensitive areas like homes or churches? It's one thing to put an LPR on an interstate. It's another thing to put that LPR in front of somebody's home to track their coming and going. It's another thing to put it on a mosque and to track parishioners coming and going, right? So let me try here. You have LPRs fine, help 44s. That's stolen cars, right? 44s are stolen cars, yeah. And missing children. The common citizen has no issues with it if it benefits them. Absolutely. In fact, that's number 4. Okay. The Massachusetts Supreme Court. But by the way, I know people don't. Some cops are like, well, this is Massachusetts, Anthony. This is not Texas. I mean, that's not. We're going to do things differently. The answer is actually this case is spot on with, I think, what the Fourth Amendment requires. They talk about Massachusetts Bill of Rights and so forth, but it's spot on with the analysis. So don't if you're thinking that, you're thinking, well, I'm not sure this applies to me or my state. Be cautious of that logic. I only bring you cases which I believe have that nationally can be defended under the Fourth Amendment. So let's say we turn all those LPRs, okay, in Las Vegas, all those intersection cams into LPRs, but we only use it for silver alerts, amber alerts, and stolen cars. Are we good? Yes or no? Correct. Right? First of all, the stolen car, here's the problem. For that guy, the guy has no reasonable expectation of privacy in a stolen car. Number 2, the amber alerts and the silver alerts, those are exigency. Those are emergencies. That is a valid exception to the search warrant requirement. Okay. I hope you guys are enjoying this. Again, this is a little off topic. These are not, but I hope you enjoy this. This is pushing the envelope on the Fourth Amendment. Now let's talk about, awesome. Okay, I appreciate it. So now let's talk about a case that was decided June 4th, 2009. Okay, by the way, just to back up, the Massachusetts Supreme Court said we're good to go on that scenario. So don't think that they suppressed the evidence. They didn't. They said that under these circumstances, right, using the LPRs was constitutional. It actually was not a search under the Fourth Amendment. It was not a search under the Fourth Amendment. Hey, it's only first-gen technology that's expensive. I assure you, you're going to be able to get these LPRs on a Walmart shelf in a few years. All right, now let's talk about a case that was decided last year in a federal court in Massachusetts. So here's what happened, okay? Let me just go back here. So Nina Moore Bush, actually I got pictures. Okay, so Nia, right, lived in this house. Actually, it's a pretty nice house. Massachusetts is one of the most beautiful states. I mean, it's just, this is a nice drug dealer's house. I'm gonna let you know, right? They have some class in Massachusetts. They really do. So she lives in this house, and also her daughter lives in the house, and so forth. So they both are dealing drugs. The police, they put a pole camera on that pole, right? And then if that camera faces the driveway in the house. The camera is up there for 8 months. It records 24/7. It's movable, right? Zoomable. It doesn't look inside the house, but it can see plates and so forth. When the agents and the cops go back to review the video, the software automatically skips over dead spots, right? That's easy. So when the cop comes in the next morning to review the footage, all he is watching is what happened in front of the house. Now, let's back up here and just look at some core constitutional principles. Does a person necessarily have a reasonable expectation of privacy of what they do in their front yard and where anybody in the world can see it, right? Driving by and so forth. There you go. There you go. Ask 100 people. Ask 100 people. Hey, 100 people, if I'm in a patrol car, undercover or whatever, and I drive by and 2 people are hanging out in front of their house and I see a drug transaction, is that a private act? Did I conduct a search in the Fourth Amendment? They're like, hell no, right? Now, the one that's selling the weed will be like, I think you did. But most people are going to say no. So, are we good here with this camera? Yes or no? Consider Carpenter. Yes or no? Yes, no, yes. It is only their house. It is only their house. Darren is saying no. Darren, guys, get it. You gotta put that out to everybody. You gotta put the, okay. Okay. Let me share something with you, okay? Let's go back to my test. Let's go back to my 100-person test. Hey, 100 people. Driving by your house and seeing something in plain view, are we good? We already know the answer, okay? Hey, 100 people. Can I point a secret camera at your house? And can I watch it and record it for 24 hours a day for 8 months straight? And can I just fast forward to all of the junk that's not necessary? And can I then use that information against you in a court of law? Am I violating your reasonable expectation of privacy? Yes or no? Therefore, the answer is what? It is a search. If the answer is yes, if a reasonable person would believe that this type of surveillance is so intrusive that it would be a search under the Fourth Amendment, then what do you need? Tell it to me. What's my acronym? CREW. Thank you. It's CREW. Do you have consent? Now, they have consent from the utility company, but they need consent from the person whose rights were infringed upon. It's not the utility company, it's it's Nia and her daughter. Do you have a recognized exception? Well, here's the deal. The recognized exception was plain view, but because Carpenter changed the rules about what is reasonable, now we look, could the cops in 1791 could they have watched a home for 8 months straight, 24/7, right, with one cop? No, no. Now, if the federal government wants to put 16 agents on the case and watch the home for 24/7, they can do that. They can do that. And they have done that with terrorist suspects and so forth. But here's the problem. If we allow the government to put that camera on that pole and not require the 16 officers, but just one, isn't the meaning of the Fourth Amendment kind of dead if we just allow this and we just keep going? Isn't it pretty much done, right? That's correct. Franco's right. We can do man hours, but that is the point. You have to, that's what they're looking at. They don't want technology to just short circuit the Fourth Amendment. It's kind of crazy. And that's why I'm bringing this up. Hold on. You guys have some good questions. Let me increase my chat. Guys, if my Zoom crashes again, I apologize. I'm like, man, please don't crash. I will be right back, but I have to figure out what's going on with, I think it's my internet. Something's going on with my internet. Okay. Jacob says that may lead to harassment lawsuits. It may, but you ain't going to win. They're not going to win because you have a right to be on green, right? You know, you've taken my curtilage class. That's open field. You can be there all day long if you want to. If we use a trash pull for a warrant, our state's attorney requires us to capture someone from the residence placing the trash at the curb. We use this up a camera to capture it rather than sit overnight. Good. Do it. Do it. Why? It's not the same thing, right? It's not the same thing. Do it. It's not the same thing. Capturing somebody 1 day, 2 days, and then manually looking at the film is not 8 months of recording. We don't know where the line is. I cannot tell you guys right now that 72 hours is the cutoff point. I cannot tell you that. I cannot. But we do have to start addressing this issue with technology. So if I'm doing surveillance and I have my dash cam on, the difference is that, what is the difference? Cody, you tell me, what is the key difference? Correct. That's exactly what it is. You're there. It's a human being being involved. I know this sounds silly, but it is a factor. It's an important factor. Can we use a neighbor's Ring camera? Yes, correct. You can use it. And by the way, you know, if a neighbor has a camera system that can record for 3 months of activity, it's different. It's different. One of the reasons why it's different is that the neighbor is not a police officer, right? The Fourth Amendment does not apply to that neighbor. All right. So the answer is you can use that neighbor's camera. That is not a carpenter issue. What we're trying to focus on is what are police doing? If police set up a camera for 3 months and it's recording only when activity, we have a totally different issue. Especially it's targeting a home, it's hidden, it's automatic, it records, and so forth. Put a camera up enough times for long enough, and eventually you'll find out what the timeline is when your name is on the case law. That's awesome. Correct. Odessa, not a government agent. That's exactly right. Consent comes from that neighbor. But by the way, again, it's just different in its nature. Security cameras that are put up are just different. They're not government surveillance. They're not government surveillance. Charleston City PD is providing Ring cameras downtown for free. I think that's awesome. Damn right it's awesome. And it's not government action, right? Once you give out the camera, that's private action. All right. So we asked the 100-person. The answer is yes, that's intrusive. The Supreme Court recognized that long-term tracking of a person's movements provides an intimate window into a person's life, revealing not only his particular movements, but through them his familial, political, professional, religious, and sexual associations. It's just the way it is, right? You gotta, that's what makes this so different. It's not my guy with the camera grabbing who's putting out the trash. That is not what's going on here. This is long-term surveillance, and it's recorded, it's automatic, it's computer analyzed to get out the junk, I'm gonna give you a case where the rule might be a little different. Our department started a volunteer program for residents to enroll if they have doorbell security systems. We don't have access to the cameras, but have a database of people to reach out to. Good. That is essentially, that is the modern equivalent of neighborhood watch. That's the modern equivalent of neighborhood watch. Now, I guarantee you, I don't guarantee you, but I believe that there's likely a department out there that does have access to those cameras. And I assure you, if they do, carpenter is going to come into play. If a person refuses to give up video from a ring in a shooting, can the police confiscate it? The answer is yes, if you can articulate that that's material evidence and so forth. But I would like to get a subpoena for that if you can. So, but if you believe they're going to destroy it, then you're going to have to do some kind of exigency. So I would articulate two things. One, it's material evidence. That means that you need it for your case. If you have somebody else's camera that pretty much is clear and it shows who the shooter is, I would not be pushing the line on that. But if you need it and you have some form of exigency, which you probably do, then I would grab it. But that I would grab it. But I don't work for your agency, so make sure you're talking to your DAs and so forth, because you don't want to get sued. You know, you may get sued, but you don't want to lose. Nor does the government have any business tracking a homeowner's hobbies or regular trips for appointments. Perhaps people would hesitate to have supporters of opposition political parties visit if they knew that the government might be monitoring their driveway. The continuous video taken by the poll camera thus threatens to chill these religious, political, and social activities. Right? Think with it. Maybe you don't agree, but think about it, right? Finally, our final case of today is United States versus Rafiq Brooks. It was decided in Arizona in 2012. This case is pre-Carpenter, but I think it's still good post-Carpenter. Okay, here's what happened. Rafiq was the target of a DTO, right? A drug trafficking organization out of Jamaica. The DEA believed that he was moving a lot of weight, marijuana and so forth, through the Arizona area. So they put up a poll cam for 24 days. Now, here's the apartment that Rafiq lives at. Okay, it's actually pretty nice. It's in Scottsdale, and so right? It's actually one of the better drug houses I've seen. The camera is pointed towards that parking lot. The camera is on a pole very far away. So Rafiq and nobody else knows the camera is there, but it was put on with permission by an arena that's nearby. The camera does not record. It's just a live camera. So what happened is the DEA would just go in there and just manually, go in there and look around and zoom in, get license plates and so forth. Actually, no, I'm sorry. It was not, I'm sorry, back up. It actually did not, in this case, it did not get license plates. It did not, because it was too far away. But they would just see what Rafiq was doing, who was visiting him, and then they would trail the car, run the plate, and so forth. Are we good? Yes or no? Good. Right? Ask 100 people. And what's the key difference here, right? First of all, they said, look, well, consent. They had consent for the last one too, though. They had consent for the last one, but they don't have consent from the apartment people. They only have consent from the arena that put the cam. But they had consent from the utility pole camera too. But what's different here? Do you think it makes a big difference? Jeff, say that to everybody. Don't hog your wisdom to yourself. Share your knowledge, Jeff. Share it, baby. Share. I'm not even going to repeat it. You got to repeat it. All right. Jeff is taking a while to cut and paste that. But Jeff said, there it is. That's key. Not recording. So there's actually two things here, okay? One, it's not recording. Doesn't that require manpower to really be doing this? The answer is yes. I'm just telling you, manpower is different than computer power. Because if computer power and manpower were the exact same thing, then the Fourth Amendment is dead. It's just dead. I mean, go look at the NSA, how many emails they can process in one day. You know what I'm saying? The other thing is where is it pointed? It's pointed at an area that does not have a lot of reasonable expectation of privacy. Do you guys agree that an apartment parking lot is very different than the front of a house? Yes or no? The evidence points to the fact that a person would not be required to be a complex resident to see the comings and goings at the apartment. Well, we also had that at the house too. People can drive by, but it doesn't end there. And any expectation of privacy by defendant in the complex parking lot surveillance was unreasonable. It's unreasonable. He's in a parking lot. Therefore, law enforcement use of a pole camera did not violate the Fourth Amendment, and thus there was no need for law enforcement to seek a warrant before using the camera. Binoculars are different because they're human. There's human eyes behind the binocular. That's really, I know, and some cops may not agree with it, but look, right? If you allow, if a computer can replace a cop, we can produce, if the ability of a computer and cameras, right, to watch everything that you do is infinite, is absolutely infinite. If the Supreme Court said go for it, if you can use a camera and a computer, go for it, then you don't really need police officers. You got RoboCop, right? Who authorizes a police camera to go up initially? It all depends on your court system. Whoever you go to, whatever judge has authority. Now, by the way, Pennsylvania, I'm sure, has some statutes on this issue too. So I'm talking about the Constitution. You also don't forget that you have state laws in place. I'm sure, and my buddy, my attorney on here can probably say yes or no, but I'm pretty sure California has specific statutes on this issue. What do you think, my attorney friend? Yes or no? It has to be. California has a statute on ashtrays. I mean, it has to. I'm sure the answer is yes. There's some kind of electronic surveillance issue in law in California. So don't forget, what we're talking about here is the Constitution. We're here to talk about the Constitution. So major takeaways here. 1, cameras may be searches. They may be a search under the Fourth Amendment. If they're highly intrusive, right? They have retention capability. That's important. So LPR is only capturing license plates. It retains a year. But a camera that's focused on a house and recording every single thing that goes on in front of the house, that is fundamentally different. That's capturing all of your associations. You know, Bernie Sanders supporters going to your door, Trump supporters going to your door, and maybe some other controversial groups going to your door that you don't want people to know about. I'm just saying, right? It's capturing who your friends are. Also, the manual viewing of public areas. If you are just doing real police work, right? Shoe leather type stuff. If the camera is just assisting you doing shoe leather stuff, then you're likely not a carpenter. Remember, carpenter is all about taking information, that's vast amounts of information, and putting the pieces together. It's called the Mosaic Theory. If that's what's going on, then we probably have a search under the Fourth Amendment. But if we have a shoe leather situation where you are looking at the camera and you're like, okay, this guy, I know this guy, and oh, here's his plate. Run that plate. Oh, he has a record? Okay. What else we got? Then it may not be a carpenter search. I hope that helps. All right, Franco. Okay, let me see here. Got some feedback here, so make sure I'm standing. Let me make sure I look for the question here so I can kind of parse it. This came just to me, by the way, which is no problem. So, okay. So actually, I'm going to give some feedback now. So there are cases out there, okay, that talk about poll cameras not being searches. In fact, that's one of them, the Arizona case, right? But here's the deal. A lot of these cases were decided before Carpenter, which is what, 2018? So Carpenter changes the analysis. Carpenter changes the analysis. It's no longer, in the prior cases, what the rule was, right to be, right to see, okay? Plain view, your classic plain view argument. Does a police officer have the right to go to a utility company and ask them to put a camera on their telephone pole or utility pole, yes or no, right? Right, of course. But it doesn't end there. It's not only about right to be, right to see. It's about tracking people. It's about being intrusive. And look, all I can tell you is that it's not just about right to be, right to see. It's also about, are you able to put together a large portion of a person's life, right? Without, are you allowed to put together a person's life with the flick of a switch? That's the problem. That's the problem. And we don't have a lot of case law on this. When I saw this case come out, again, when I do these search and seizure Saturdays, I'm just looking for a latest case. It could have been a gun case. It could have been a motor vehicle search. And I saw this case. I'm like, holy shit. This is a good time to actually talk about poll cameras. And by the way, I have no hard and fast rules for you. I don't. I have no 72-hour rule. I have no 2-week rule. I'm just telling you, if your camera is pointed towards a highly protected area, like a home or a church, maybe not Burger King, or a business, or someone, but if it's pointed towards a home or a church, and it's recording 24/7, it's up for a long period of time, and that software helps you go through a vast amount of data, and you can start putting together somebody's life, it's likely a search under the Fourth Amendment. So, and by the way, I love just fleshing out these issues. So, you know, and I don't have a lot of, again, I don't have black and white answers for you. I have context. All right. So somebody asked, what about a park that we have a lot of cameras, or what's BMVs? That is building mounted cameras, right? Good to go. It's good to go. Remember, what these cases are focused on is not the public sphere. They're not parks. They're not Times Square. If you go down Times Square, that place is loaded with cameras, right? You can't pick your nose without some cop seeing it on camera. I tried. We are talking about right now, the case law is focused on homes, pointing the camera towards homes. So, not an issue. If you are going to do extended surveillance on a home, get a warrant. Extended surveillance on a home, I would get a warrant, especially when it's 24/7 recording or something like that. Would it be beneficial to periodically suspend the surveillance, document those times, and then put the camera back up if you're going to do a long term? Sure, that's going to help you. But here's the deal. I don't have the number yet about how long is too long. I don't. My gut reaction is anything over 2 weeks is pushing it. That's my gut. I don't know, though. I just don't know. I don't know. Correct. Darren says, when in doubt, always get a warrant. And that's my thing. I mean, sometimes you don't have enough to get a warrant, but if you have enough to get a warrant, go run to the courthouse. Or I'll give you another one, okay? If you put up a poll cam and you see something on there that gives you enough to get a warrant, why don't you just stop the surveillance at that point? Maybe it took you a week or so, maybe it took you a few days. Why don't you stop it at that point and go run to the courthouse? How about that? I think that's good advice, right? Exception. So a crew, right? It's in the book too. Crew is, do you have consent from somebody who can give it? Do you have a recognized exception? So really the proper term is a judicially recognized exception, a JRE, but that's stupid. We don't need the J. We just need to recognize. They would mess up my crew, right? Crewja. J crew. J crew. So recognized exception. Do you have cases that tell you can't do what you can, right? Like this. Do we have cases that try to put us on notice that may be overly intrusive searches? And finally, warrant. That's what crew stands for. No. Okay. John, I wish you would have said that. That's a great question. John said, will a poll camera violate Jones? The answer is no. Because Jones is, the majority opinion is focused on a trespass. Poll cams do not trespass on people's property. There is no physical intrusion. But the birth, okay, the birth of Carpenter was in Jones. What I mean by that is one of the issues, Jones is that GPS case where the feds put a GPS tracker on Anton Jones's car for 28 days and got tracking data. One of the issues, one of the minority opinion said that one of the reasons they didn't like it was not just that they touched the car and so forth, it was that it painted a picture of his life. And that was the Mosaic Theory. That theory was then codified essentially in Carpenter. So the answer is no, but that's where it got its legs. So very good question. All right, I'm going to put this up because I want you guys to, again, I want to remind you, I do search and seizure training full-time, right? Tuesday, Wednesday, Thursday. Guys, we have an East Coast class. That's going to be by Ann Kelleher. Tuesday is advanced search and seizure. Wednesday is advanced traffic stops, and Thursday is advanced criminal interdiction or investigations. I'm teaching the Central Time class. So it's open to any officer, right? Any officer. So, Jacob, I'm doing these search and seizure Saturdays every single Saturday for the foreseeable future at noon every week. So, and they're kind of like this. So just, you know what? Let's find out what we're going to talk about. I don't really have a game plan. It's just, I look through some cases and I try to find something that we can talk about and move the conversation forward. So every single Saturday, I came up with a great, clever trademark name, Search and Seizure Saturdays, and watch my competitor start Search and Seizure Sundays. All right. So consider joining me or Ann. What is the time for the Advanced Search and Seizure East Coast time? It starts at 9 a.m. East Coast. 9 a.m. East Coast. And Central Time starts at 9 a.m. Central Time. So 1 hour difference. 1 hour difference. Thank you. I appreciate that, man. Thank you. I'm doing the Central Time. Yep, I'm doing Central Time. You're welcome, guys. You're welcome. So cheers. I'm glad we actually had a good conversation. Yes, just to clarify, the LPR case, actually, the LPR case, it's not even reasonable, yes, but it was not a search under the Fourth Amendment. It was not a search under the Fourth Amendment. So you don't have to be reasonable, but I know what you're saying, but it was not a search because it's not highly intrusive. You're welcome. Oh, man, Kenneth got through the whole thing. Awesome. So 1510 Central. You're welcome, Franco. And also, if you want something more from me, like some more cases or something, just reach out to me. And by the way, I'm not sure if I'm familiar with that exact case name, but I'm going to read it. And if I change my mind on something, I'm going to let you know. Okay, Franco. I'm not. Yeah. Let me just look at it. Let me make sure that that doesn't change my mind. Okay. So, hey, Rick, do me a favor. Do me a favor. It's hard for me to move my. Will you copy Franco's comment to me and send it to me so I can get that case? Okay. Thanks. I appreciate it. Okay. So Justin says, can you break down the classes a little bit more, or recommend if someone can only attend one? You can attend one or all of them. You can attend traffic stops on Wednesday or advanced search and seizure, which is like the bedrock. That's really where I show you how to think like a lawyer and to think about how to solve your problem, your search and seizure issues. And then day 3 is advanced criminal investigations. That is some deep stuff. You'll know as much as many lawyers on search and seizure issues. But you can take one or all, and they're also 50% off until the end of April. After that, we have to go back to normal business, right? We got to get back to normal business. So you can take one or all. I recommend that you take all of them though, if you can, or take one. So no, somebody's asking me about Rockwall, Texas class. That class is canceled. However, the physical class is, but it's been moved online. So it's been moved online. If you are registered for that class, we are doing that class online. But the days are different because we also had a Fort Worth class. So we're combining our Fort Worth and our Rockwall class. So we're going to be online for Texas. Anybody can attend, but that class is Tuesday, Wednesday, Thursday. All right. Anything on Terry Frisk? I can do a class on Terry Frisks. Do you want me to do a class on Terry Frisks? I don't have it today. Okay. I'll make a webinar on it. Okay. I have a question regarding the best way to reach me is my email address. Rick will put it in there. And if your question is long, right, you just want to talk, maybe even call me. It's probably better because sometimes it's easier for me just to call you. But reach out to me and let's just go from there. I have a question regarding search and seizure. You smell marijuana in a car. The owner takes full responsibility for it, but you have 3 people left in the car. You're going to search the car, right? And how can you justify searching the other occupants who may also smell like marijuana? So here's the deal. It's not just, look, I don't like when cops search people because they smell like marijuana. I'm not an advocate of that logic, because people can smell like marijuana because they hang out with people that smoke marijuana, right? So here's my deal. If you can tell me why you have probable cause, why a particular passenger, either one or all 4 or 3, if you can tell me why you have particular probable cause of why they have marijuana on their person, how do you get that? They're abnormally nervous, conflicting stories. They admit to you being a smoker of narcotics. They have a drug history. The driver says that they were smoking as well. They may have paraphernalia on them. It's not just maybe the driver's holding the weed, but maybe they're holding their own paraphernalia, right? That is what you need. I would not search people and go to court and when asked why, say, Your Honor, because they smelled like marijuana. I do not think that is a good search. That's kind of where I'm at on it. And the book, by the way, and Jacob, did you get, I think you got this book, right? So I think you got this book. Oh, you're working on getting, okay. So, and the reason I bring it up is because this is, I was making a joke that this is like the Bible. Let's turn to verse 3, chapter 4. And we talk about, oh, Heavenly Father, what's an active drug user? And in the book, I talk about all the factors about how you can also articulate an active drug user and also somebody's engaged in narcotic activity and so forth. So, you know, your criminal history, your guilty mind reactions, evidence of drug use, deceptive behavior. You get my point. That's what we're all about. Well, here's the thing. Again, being under the influence may not get you to the finish line, because what's not to say that they smoked weed with the driver at his house and that are just cruising around looking for Taco Bell, right? You still got to, in other words, here's my, you know, okay, hold on. Okay, so here's what I have to say at the end of the day. Imagine that you're going to go to a judge, okay? And you're going to say, Judge, I want to search that passenger for drugs. The judge is going to ask you, well, why do you have probable cause? What are you going to tell that judge? If you say, Your Honor, the person smells like marijuana, there are some cases out of New Jersey that uphold that. I do not believe, well, back up. That's not even true. The cases in New Jersey do not say smell marijuana, you can always search. Usually there are other factors in that case, right? That the persons were lying, that there was something in the car as well. I mean, I'm just telling you that if you're walking down the street and you smell marijuana, I just don't know if you can just snatch that person and start searching them. I'm just telling you, I would like more facts. That's what I teach, at least. Oh, I see. Okay. Yeah. So does it matter in states where marijuana is not legal at all? It's better in states that are not legal at all. But again, I just don't like when cops, all they tell the court is I smelled marijuana. I don't know. I could have a field day with that officer if I was a defense attorney, because there are many legal reasons why somebody could smell like marijuana. Now, but let me just kind of change. Tell me, hey, he smells like fresh marijuana or raw marijuana. You're good. He's in a car and he smells like burnt marijuana. You're good, because now he was smoking and driving and he probably has paraphernalia on him. So to say the least, a person would allow you to search for the paraphernalia. But walking down the street, you pass somebody, they smell like they've been around marijuana. I don't teach it. Oh, gotcha. Right. I should clarify. I'm talking about passing the guy on the street, smelling marijuana, grabbing the guy and searching. That's what it sounds like cops are doing. But put him in a car, different. Put him in a car, it's totally different. Correct. So crew is for consent, recognize exception. The E is the exception. Recognize, but it's a phrase. Recognize exception means a court case, and warrant, and W is for warrant. Yes, I generally speaking would search the car first, because then you also may have time. You may have probable cause to arrest, which will give you, right, another reason to search. That's good too. These are complicated. I mean, look, I got to tell you something. I mean, some of the things I talk about, you know, some cops are like, well, I have a case that says the opposite. I'm like, that's cool, and I understand those, but I'm trying to teach best practice, and I'm also just trying to teach like good case law, right? Sometimes you can get away with stuff, and the courts will be like, yeah, you're good. But I'm also thinking about if your case goes to the U.S. Supreme Court, what would they say? Would they be like, yeah, you are good to go? Well, sometimes with the facts, I get, I'm like, I don't think they're going to say that. And that's just understand that that's part of what I bring to the table is I'm not just looking to ride the edge. I'm also looking to win case law, because bad case law is not only bad for you, it's bad for other cops. I hope you guys appreciate where I'm coming from on that. Right. Okay, guys. Yes. So give me a here. I'm gonna text it to you right now. Boom. You're welcome. All right, guys. If that's it, if you have nothing else, have a good weekend. We'll catch the Rona. You're welcome. Take care, guys. I'll see some of you guys next week. Hey, Rick, did you grab that case from Franco? Remind me, because I was going to look through it through the chats if I have to, but before I end it off. Oh, you did? Okay. All right, cool. All right, guys. Thanks again, man. Is that Min? I just saw you here. What's up, buddy? Yeah, that's awesome. Good to have you here, man. Yeah, you too, man. You too, David. Now, Min, I think you're out of. Min is out of. Oh, you did. Remind me. You are California, right? Yeah. That's what I thought. No, Austin. Okay, a little bit difference. Okay. All right. Even Ricky got it wrong. Austin. My dad actually just moved to the Austin area. He's actually driving back right now. He's driving to California to go pick up his shit and move back to Austin permanently. Thanks, David. I love doing it, man. Spread the word, guys. We actually had a pretty decent amount of people on here, but spread the word. Please spread the word. Yeah. Waterbury, Connecticut. Give you a shout out. Awesome, man. I think that's just fantastic that the Connecticut cops are here. That's just fucking fantastic. It's awesome. Yep. See you next week, Clayton. Okay. Maybe that's why I had California in my head. That makes sense. You're welcome, brother. And I got that email, Rick, so we're good. Yep. You're welcome. We're going to keep it going, guys. Just help me spread the word. That's all I ask. Help me spread the word, and we are good. Because that gets, me exposure to other officers. I want to hear what they got to say. I want to hear what their issues are, right? So I can keep doing this training. So I appreciate it, buddy. That's not it, Rick. He's asking for Miranda. That's interview and interrogation law. That's a good one. You haven't been to that one yet, Jacob? I almost think you've been to all of them now. I guess you're. Okay, good. You're becoming a Jedi, my friend. Use the Force wisely. Use the Force wisely. Oh, gotcha. Right. There it is. May 6th at 6 p.m. So a little far away. That's the soonest one, huh, Rick? Hmm. I'm getting lazy. Hey, you're the lazy one. Where were you at 1 a.m.? Where were you at 1 a.m.? I was here. I mean, we had over 100 cops. You was at the club. Yeah, I was doing the graveyard shift. You're at the club. Mom was here. Is Kathy B? Is Kathy B still? Mom, are you still here? Mom didn't miss it. Nope. All right, guys. I guess we're done. Bye, Mom. Bye, Rick. I'll talk to you later.